Is a substitute for this bill.
Joe, you second that?
Yes.
Okay, it's been moved and seconded. We adopt the substitute. All those in favor say aye. Aye. Anybody opposed? Great. Substitutes before us.
Okay, so the substitute returns the bill back to essentially the introduced version, which was the add-in of the old repealed section of 18.2-62, which was the testing of persons for, then it was HIV. This bill the substitute makes a couple changes. One, from the old language. One, it expands sexually transmitted infections to include chlamydia, gonorrhea, syphilis, and then it has the 3 diseases that were in the previous code section: HIV, hepatitis B, and C. The other thing the substitute does is it requires that the person to be tested, there has to be a nexus between the person being exposed to the virus and their need for testing. And that's going to be on lines 15 through 17, and where the complaining witness was exposed to body fluids of the person so charged in a manner that, according to the then current guidelines of the CDC, transmit a sexual infection. So this way, the person who wants the testing must show that they've actually been exposed in a manner that would, cause such testing to be necessary. And then it has the provisions that require a hearing, which was in the old sections. And then it does have a few more provisions. A new line is on lines 30 to 31. It was unclear if counsel could appear at these hearings, and these changes make sure that counsel, if the person's charged, he can do it pro se, or his counsel may appear. And also those lines appear on 48 to 49. The reason why there's an A and a B has to deal, I believe, with the federal VOCA funding. There was a question as, if we're doing this as soon as practicable following arrest in subsection A, do we really need that, considering B is following indictment, arrest by warrant, or service of petition in a juvenile? And the answer is yes, because subsection A is what's tied to the VOCA funding, from my understanding. And subsection B was a long-existing law, which A was, I believe, added sometime in the early 2000s to comply with VOCA funding. And then the other clarifying language is going to be in subsection E, which talks about what these tests can be used for, and basically says no test shall be admissible as evidence in any criminal proceeding. No specimen obtained pursuant to this section shall be tested for any purpose other than for provided in. And then a violation of this subsection will constitute reversible error in any criminal case for which the specimen or results was used. And this language does appear in the 32.1 sections that deal with healthcare workers and public service employees, that, if they get a needle stick or exposed to some sort of STI, this language is taken from that section. So those are the current protections for essentially people who are exposed outside of a, criminal act. And that's pretty much the substitute and what it does.
Okay, thank you, Counsel. Senator Donovan, is there anything you'd like to add to what?
No, I'm very grateful for council's help in cleaning this up. Appreciate it.
Okay, thank you. Thank you, Senator Donovan. So, to the committee, one of the side conversations I had with counsel this morning before we gavelled in, is I had a concern that the definition of sexually transmitted infections was too broad. If you look at the very last line of the bill, it's defined to include chlamydia, gonorrhea, syphilis, HIV, Hep B and C. But the remaining language about any other sexually transmittable disease required to be reported by the Board of Health pursuant to this statute, I had concern that could include something like the flu or COVID or something like that, which I don't think was really what we intended, because that could be every single domestic assault case where fists were flying, maybe spit was flying around or something, the way this is drafted. And counsel, I don't know if you've looked, but unless 32.135 specifically defines the diseases.
Mr. Chair, so to answer your question, basically 32.135 says the board shall promulgate from time to time a list of diseases, and then it does say the board may classify such diseases, but there's no restriction on how the board may classify it or what diseases are provided for. So the board may classify diseases as STIs, but it seems as if the board has some discretion in how they classify them and how they're listed.
Got it. So, anyway, it would be my hope somebody would make a motion to strike that last part and add a new "and" before Hep B, but,
Mr. Chairman, I'll just interject if I may. Sexually transmitted infections does have significant specificity in the medical community that it really wouldn't be relevant. I think all this does is it leaves a door open in case we find something new that we just need to add on. But I don't have a strong objection to the amendment either.
okay. Can we, sure, I'll second the motion just so we're in the right procedural posture. Go ahead.
Charles, in 32.1-35 or anywhere in Title 32.1 is sexually transmitted or sexually transmittable defined to put some parameters around what the board would identify as a sexually transmitted disease?
And Mr. Chair, I'm looking right now. There does not appear to be a defined term of sexually transmitted infection in 32.1, although they do mention sexually transmitted disease or sexually transmitted infection in 32.1, but it's just defined by its plain meaning.
I know elsewhere.
Mr. Benjamin.
Right. Yeah, yes, and Mr. Chair, to answer, I guess, there is a
yeah.
definition of venereal disease in 32.1, but again, that also, I think, leaves,
Doesn't answer the question.
Doesn't-
What's sexually
right.
transmitted?
Senator McClellan.
But if it says that you would follow the plain meaning, I mean, it's pretty self-evident what is sexually transmitted and what is not. And particularly if it's somewhere else in here, it said something about following guidelines according to the then current guidelines for the Centers of Disease Control. So I don't share your concern that it would cover the flu or COVID, because I think between according to the then current guidelines of the Centers for Disease Control and Prevention, transmit a sexually transmitted infection on lines 16 and 17, combined with a reference back to 32.1-35, which in Title 32.1 says sexually transmitted will be defined using its plain meaning. I think that gives me comfort that it's not going to cover the flu.
Thank you, Senator McClellan. Charles, can you correct me if I'm wrong, but I believe the way we got to this language is originally there was a list of diseases. I think it included herpes simplex virus, and then I think another draft circulated that had it as a sexually dangerous disease, which isn't defined anywhere, and then it got down to this, which sort of takes it back to a more broadened form. Would you agree with that?
So, Mr. Chair, there were, from what I understand, 3 other sexually transmitted infections, I believe. Herpes may have been one of them, HPV was one of them, which aren't required to be reportable to the Board of Health. And they were taken out because they were not required to be reported. And then the language of what is determined to be dangerous to public health was picked up from the definition of venereal disease, but the suggestion was made this is actually more narrow language because it's what's required to be reported to the board, not just what they determine to be dangerous. So there might be something they consider dangerous but don't necessarily require a report on, like HPV or genital warts.
Okay. Senator Morrissey.
Why are we having this discussion about the
Use
seriousness?
the microphone so the room can hear it.
Why are we having such a long discussion about the seriousness of the infection? I think the gist of your bill, isn't it, is that if somebody assaults somebody and they give them a virus or an infection or disease, they ought to know about it, right? That seems to be the gist of it. So why are we going down? Because I want to get into the bill, some of the nuances of the bill itself, but that's my first question.
All right, Senator
somebody
Morrissey, I
can
think
address
it has to do, first of all, remember we're talking about accused people here, not people who have been convicted, but Senator McClellan.
So 2 reasons. So the original code section was put in place in part because the point was if there were diseases that someone, if they contracted, could die, there should be testing around that.
Sure.
When we did the HIV modernization bill, part of the issue was it only targeted 2 diseases, both of which the science has changed so that with treatment, they're not fatal. And there's comprehensive testing done in a PERT kit. But for a couple of policy reasons, the senator wants to reinstate the code section that was amended while avoiding the problem with the underlying bill that was repealed in the first place, that you are targeting and stigmatizing HIV, which is, if treated, not fatal, but these other diseases could be.
All right, I understand that. Follow-up
Senator
question.
Morrissey.
Again,
Question to who?
Again, I don't think that the patron cares so much if it's fatal or not. It is a disease that can affect the health of the victim. And I'm not that concerned about stigmatizing testing for an HIV, the individual that may have transmitted it. If there is a possibility that a person was assaulted and was infected, I don't really care if it's fatal or if it's a de minimis infection. It is something that they ought to know. But I'm not. That's the last I'm going to say about it. Then I'm going to move on and ask some nuances about the bill itself.
Okay. Senator McClellan.
Yeah. I guess the issue is 2 issues. One, the survivor will have the opportunity to be tested themselves through a PERT kit, as it is standard procedure that the PERT kit includes comprehensive testing. The point of this bill is to determine whether someone who has been charged but not convicted must be tested. And so I think if you're going to mandate testing of someone who has not been charged, you should have a more narrow focus than you would on the testing done on the survivor as part of the PERT kit anyway.
Senator Morrissey.
Mandate somebody who has not been charged.
Convicted.
Convicted. Yeah. Right. And Senator, I would just also point out to you that, remember that this statute also applies to domestic assault and battery. So if you're in a domestic assault situation, somebody alleges some spit flies, they could have somebody test. Okay. All right. All those in favor of the amendment by Senator Morrissey, say aye. Aye. To strike out the language at the end of lines 66 and 67 after Hep B and C, so that there'd be a list that we control instead of the Board of Health.
Mr. Chairman, what line on 66 are you striking? I mean, where do you start?
Your motion was to strike everything after Hep B and C viruses and to put a new "and" in before that.
Can I vote against my own amendment?
You do whatever you like.
I'm sorry. I'm going to withdraw it.
Okay. Okay. Motion's withdrawn. Is there any other discussion? Senator Morrissey, you want to talk about the bill in general?
Yes, I do. Get down to the nuts and bolts about something. Number 1, Senator Donovan, line 11, following arrest, all right? All right, that's an arrest on a felony. Go down to lines 21 through 23. We talk about there is a probable cause that an individual has committed the crime, and are we talking about the preliminary hearing, or are we talking about a second hearing? Maybe staff can answer that.
Mr. Chairman.
Staff
Senator
could also
Morrissey.
answer Senator Morrissey's question that this only applies to felonies.
The first question is whether this, well, I'll answer directly. This contemplates a separate and discrete hearing apart from the preliminary hearing.
Okay, because I understand that. If you look at, Steve, in line 23, to determine whether there is probable cause that the individual has committed the crime, that's the very nature of a preliminary hearing.
It is.
And then it goes on to say, and the complaining witness was exposed. But just so that we are clear, in one manner, the person could almost get 2 preliminary hearings. Is that right?
That is correct.
Okay, great. Just want to make sure that we all understand that. Lastly, next
Senator
question.
Morrissey.
I'll say that's an aspect of this, I think an unavoidable aspect, because it appears that the thrust of the bill is to require this testing as soon as possible. And typically preliminary hearings won't occur until sometimes several months after arrest.
Okay.
Okay, Senator Morrissey.
Thank you.
Keeping in mind, full committee starts in 5 minutes.
Yeah, thank you. We spent a lot of time on the other matter. Page 2, at any point following the indictment on lines 32, okay? Just want to make sure that and then you go down to line 41, the court with jurisdiction of the case shall hold a hearing to determine whether there is probable cause that the complaining witness was exposed to bodily fluids. Senator Donovan, Steve, or Charles, what you're doing, often an indictment is done so that the defendant cannot avail himself of a preliminary hearing. This case, the defendant most certainly can, because it says the court shall hold a hearing.
That is correct, Mr. Chairman, Senator Morrissey, and that would be a strategic reason why a Commonwealth's attorney might counsel an accuser not to demand the request be honored. Sometimes the strategic concern is you don't want to be cross-examined twice. But that last observation raises one question unanswered by the bill. On line 31, you see the provision that a person charged or his counsel may appear.
Yes.
The bill in that doesn't answer the question, what does that mean? Can they simply be there? Is this memorializing their right to be present so that it's not an ex parte proceeding? Or does it also mean that they may participate? And so that's a policy question for the patron and for the subcommittee, is to what extent should counsel be, or the person accused, be permitted to participate? Should they be permitted to, for example, give their own testimony, denying that they had anything to do with the matter, for example? Should they be permitted to cross-examine? Those questions are not answered in the present form.
Counsel, wouldn't you agree that any time you're talking about taking somebody's blood or bodily fluid or testing for it, that we kick in some different constitutional considerations than otherwise, and that there might be problems if they're not able to participate?
I think that because at the end of the day, the threshold inquiry will be the reasonableness of the blood draw, for example. That's a Fourth Amendment consideration. If the subcommittee wished to answer that question and add the protections that typically come with, say, a preliminary hearing, then on line 22 and elsewhere as necessary, after the word hearing, you would insert the language in the manner provided by Virginia Code section 19.2-183. That is a section that describes a preliminary hearing and the rights that attend to a preliminary hearing.
All right. I'm going to move that then.
Senator Morrissey.
That includes that language just enunciated by
Mr.
counsel.
Chair, I do have a question about that, though, because on lines 29 to 30, it does say the court's findings shall be without prejudice to either the Commonwealth or the person charged and shall not be evidence in any proceeding, civil or criminal. I wonder if Steve's amendment would unintentionally cause, if the court's following the proceedings of a preliminary hearing, if that would cause confusion or not.
Mr. Chairman, it could, but I haven't spotted the confusion it would provide.
Mr. Chair,
Senator Morrissey.
I think by putting the language in that Mr. Benjamin just suggested, it does exactly what I said before. It does allow the defendant to avail himself to some degree of 2 hearings, and so be it. I'm good with that.
Okay, Senator Morrissey's made a motion that we add language to make the hearing procedurally similar to a preliminary hearing in the bill where necessary in concept. Is there a second for the motion? Second. Motion's been made and seconded. Any further discussion on that motion?
And I had said wherever necessary, so that would also be at line 41 after the word hearing.
Okay. Any further discussion? Okay. All those in favor say aye.
Aye.
Anybody opposed? Okay. Can you show that's unanimous amongst those who are present or proxied, I guess? Okay. Any further discussion about the bill, which Senator Morrissey note that it also applies to misdemeanors? You keep putting up felonies. Okay. Go ahead.
Would it be appropriate to make a motion now?
Does anybody from the public want to comment, even though it looks like this bill is probably in pretty good shape? You might snatch victory from the jaws of defeat. And we have full committee starting 30 seconds ago? Okay.
The chairs, well, one of the
Yeah, one of the chairs is here, right. Yeah, okay. So go ahead, Mr. Senator Morrissey. What's your motion?
Move to report the patrons' bill to the full committee.
Okay, it's been moved and seconded that we recommend reporting the bill as amended to full committee. All those in favor say aye.
Aye.
Anybody opposed? No, okay, okay. Yeah, there's a lot of lawyers there. Okay, committee's adjourned.